Welcome back. Here with us on Urban Debate on Mirror Now. After days of firmly defending the colonial era sedition law, calling it a good law and dismissing the need for any reconsideration, the central government has now decided to re-examine it. And for the same, the Supreme Court has given time to the central government until tomorrow morning. Chief Justice N.V. Ramana has asked government to reply by tomorrow on whether the sedition law can be paused and people charged under it can be protected while the government reviews it. And what should now be done because now the government has to respond by tomorrow. Let's understand this particular issue from former Law Minister of the country, Salman Khurshid, who is joining us live on Urban Debate on Mirror Now this evening. Mr. Salman Khurshid, thank you very much for joining us live on Urban Debate on Mirror Now. Firstly, how will you like to respond to this sudden U-turn by the centre that happened yesterday? Because still about a few days back, the centre was talking about maybe providing some clarity on guidelines that should be there. And centre suggested that there's no need to scrap this law completely, but now saying that it's ready to reconsider it.
Well, I think if it's a positive step, we should welcome it. This is not a matter of partisan politics. This is something about the state of affairs and the rule of law in our country. And anything that is supportive of it must be welcomed. And I think credit ought to be given for it. We are all, and I believe a large number of people in the country, thinking people, have opposed 124A, and the government has been sensitive and is therefore responding to it. I believe that it's a good thing. It's a good sign.
It's a good sign. Now I want to ask you, as a former law minister of the country, what should the centre be doing? Because now the Supreme Court has asked the centre to respond on one very important issue, and which is about the pending cases or the future sedition cases. Should these cases be put on hold till the government actually reviews this particular law?
See, very clearly, when something comes into question, the court is not very clear at that stage before hearing the matter as to which way it would be inclined. And the court then reserves its and awaits the actual hearing. In this case, it's been a little more transparent. The court has taken a prima facie view that there's something wrong with 124A, and it's high time that we dispensed with it. And the government has now come on board. Now, if that's the case, and government says we need a little time to consider what to do and how to do it and when to do it, the court, of course, said that's fair. We should give you some time. You should have some time in which to be able to take the right steps. But whatever time you take is a critical time for those who are already suffering as a consequence of 124A. And there may be other people who would come to grief because of 124A in times to come. So what are you going to do about this? And I'm surprised that the government wasn't ready with an answer. They said that, look, it's too soon, it's too urgent. There has to be a debate, there has to be a discussion, and we're not really be able to do very much right now. And after all, and then they switched back to national security and switched back to sovereignty. But the court, I think, made it very clear that it wants to be able to intervene with some relief in this matter. And therefore, they've given government time till tomorrow to come back with their proposition. And thereafter, the court may actually reserve orders and pronounce orders, which would be very welcome if they're going in the direction in which we saw the court act today.
Mr. Salman Khurshid, with the way sedition cases have been filed in the last few years, we have NCRB's data as well, where we see conviction rate being extremely poor. Do you think government, by saying what it said in its affidavit yesterday in the Supreme Court, is trying to, in fact, get some sort of a breather? because the Supreme Court had made it clear, in a way had given an ultimatum to the centre. It was supposed to take up this matter today, and decision was to be taken whether it should be given to a larger bench.
Yes, I mean there are two views on this. There are both the government had taken the position and some counsel had taken the position that, including the lead counsel in this was Mr. Kapil Sibal, had taken the position that we could produce the arguments before court of the 3 judges. We didn't have to be referred to 7 judges, though many other counsel felt that it would not do without being referred to 7 judges, and 1 or 2 of the judges on the 3 also indicated that perhaps it requires a reference to 7 judges, because the judgment that would come under a cloud because of these arguments is a judgment of 5 judges, and that's Kedarnath Singh. So that's the status of the game as of now. The trouble really is that there are many other provisions that can be used to address those concerns of government and of a responsible government. In the absence of 124A, there is 121, which is waging war. There is 153B, there's 153A. So there are many provisions that could be used in order to address any act of violence that is followed by speech that is provocative, or speech that is hurtful, or speech which is divisive, and so on. So I think this is what the court had in mind, but it wanted the government to come clean on what it can do. And there were many suggestions made by the judges. Now we finally will know tomorrow morning what the government finds feasible, and if that or more than that is what the court will decide.
Will you, Mr. Salman Khurshid, who's been the law minister of the country in the past, say that sedition law should be scrapped? Is it a bad law? Remember, former Prime Minister Indira Gandhi made it a cognizable offence. The teeth that it has today were given by Ms. Indira Gandhi and Pandit Jawaharlal Nehru as well when he was the Prime Minister.
We didn't freeze in time with the decision that were taken at that time after independence and subsequently. The context of the time and the situation, ground situation, all have to be factored in. And of course, ultimately, public opinion. Public opinion has to be factored in. The public opinion may have supported it that time. Public opinion does not seem to support it this time, despite the fact that there is great divide on many matters in the public. But as far as this is concerned, there seems to be widespread consensus amongst activists, amongst people of the right wing, and amongst the people of the left wing. And therefore, the best thing to do is to get rid of it. And that's what might be necessary. Now, of course, the government might assume that if the court is left to do this, the court will just wipe the slate clean. Whereas the government may well have an opportunity to make some amendments and to make some exceptions and to find some alternatives, etc., by way of the legislation that would be required to outlaw this. So I think it's a matter of tactics, and it's a little bit of a matter of careful weighing of options. But that will become apparent tomorrow onwards, or perhaps we'll have to wait till the court finally takes up the hearing and decides what to do with this.
Interesting. You say, we need to weigh the options carefully. So let's talk about the options that are also there on the table. And I want you to address this. Now, there are 2 elements to this law today. One, threats to sovereignty. And second, the vicarious use of this law to shut reasonable dissent against government by writers, poets, and journalists as well that we have seen happening. Can the government keep the part against real threat and amend law to ensure misuse against minor dissent instead of scrapping it completely?
Don't forget that Article 19, which is about free speech, was at the forefront when Kedarnath was decided many, many years ago. And there the court had relied upon Article 19 and said that the protection will come by way of Article 19. But we've seen from then to now that protection that is built into the Constitution is not working. There are many judgments that have been given in recent years, in recent months, in fact, the last one being that of Vinod Dua and so on. In those judgments, this has repeatedly been underscored that this is being misused, and this is a clear misuse of the law. The Solicitor General even suggested that since the Constitution and constitutional courts are there available to anyone who has a grievance, we don't need to interfere. But the court paid very little attention to that argument. So, in fact, the real problem is, and as the court also said, that it's not what the Supreme Court or the High Courts actually state in their judgments, but what the policeman on the ground does. And by the time you are able to intervene, a person has already suffered grievously. And therefore, it's time that it would go. There is a clear distinction between the state and the government, which is why I said Section 121 of the IPC, waging war against the country. So the state / country and the government, and an elected government in a democracy is different from a foisted government of the colonial times. And therefore, you may be extensively, aggressively against the government, but that does not mean you're against the country. And I think very felicitous and a wonderful way in which the Allahabad High Court in one of the recent judgments about shouting of slogans at a cricket match has said that the state is not like the like weeds that would be swept away by a breeze. This is a solid state, and we must have confidence in the might of the state to survive. And I think this is all that will have to be considered when we talk about sedition in terms of its relationship with giving security to the state rather than to a government.
But recently, Mr. Khurshid, Maharashtra government used it too against MP Navneet Rana and her husband.
Yes, now that's happened to them. There may have been other laws that could have been applied to them, but clearly that's been a trigger and a signal for the government of the day here at the center that we are not the only ones who can misuse it. Other governments can misuse it as well. So I think it'll be unfair to take sides and say when we misuse it.
You're saying it was a misuse.
Well, if the courts have said that, who am I to say it was not a misuse? Now the point really is, as long as the law is there, the person who applies it with an honest mind might feel that this is necessary, it has to be done. What are you doing? What you're saying is, if this is allowed, it will shake the foundations of our country if this is allowed. Now, there may be a very legitimate cause for saying that or for believing that. But on the other hand, there are people who say that no matter how ridiculous you think that the government is and how much you ridicule the government, you have a right to do so. The right to ridicule is an important right. And for you on the media, freedom of expression and freedom of action must be paramount. And I think that's what the courts are trying to do.
All right, Mr. Salman Khurshid, thank you very much. That's very fair and candid of you. Thank you very much for joining us here on Urban Debate on Mirror Now this evening. Of course, all eyes are now going to be on what the Supreme Court will have to do in this case tomorrow, and what is it that the centre is going to say on the query that has been raised by the apex court of the country about the pending and the future cases. With this, it's a wrap. Thank you very much for staying with us on Urban Debate on Mirror Now. Heading into a short break, Griha joins you next. Stay with us.